So great. Well, California never disappoints. Again, in 2021, they were quite active and have enacted a number of employment-related laws for employers to take note of. Many of these are expansions of existing law, and many are industry specific. So while last year was a huge year for changes, this year probably won't require as many updates, but I will point out areas that you need to be aware of. So today we're going to talk about the COVID-19 Federal Emergency Temporary Standards and Cal OSHA's anticipated approach to the new guidance. COVID is obviously a rapidly evolving topic, and I was joking with Dawn yesterday that I might have to interrupt this presentation for breaking news, but we'll see. And then minimum wage updates and minimum salary updates, reminder of harassment training that's required for both managers and employees, severance agreements, non-disclosure agreement requirements. Cal OSHA has been quite active and expanded some violations for egregious and enterprise-wide violations, and then we'll discuss other laws that are of interest and concern. So COVID, it's a bit of a hurry up and wait. The emergency temporary standards came out, and everyone got excited and made changes, and then the federal courts have been quite active with receipt of claims in both the courts of appeals and the district courts. So at this time, although it is rapidly changing, it's also in a bit of a holding pattern for the time being. We expect that the federal emergency temporary standards are currently suspended. The implementation has been suspended pending judicial review. Nonetheless, we do recommend for best practices, particularly in keeping with Cal OSHA standards that were adopted in June, that you maintain a list of all of your employees indicating who is and who is not fully vaccinated for COVID, along with documented proof of vaccination. Now, the federal requirements, the emergency temporary standards that are in abeyance, do require documentation. Cal OSHA does not. They do allow for self-attestation. We also recommend that you review or write a vaccination policy specific to COVID or otherwise, and we can certainly assist you with that. CalWorks Safety and HR has an entire safety team and consultants who can assist with drafting all of your policies and procedures, your illness and injury prevention plans, and your COVID-19 prevention plan, which you are required to adopt and implement. With respect to the federal emergency temporary standards, they were passed on November 6th. They were expected to take effect on December 5th. As I said, that's on hold. Under the standards, employers are obligated to check each employee's vaccination status, maintain vaccination records, and maintain a roster of employees with vaccination status. There is no self-attestation under the federal requirements. And then as of January 4th, 2021, it was expected that all covered employees must either be fully vaccinated or commence weekly testing. So that may or may not occur in the future. We'll see what the federal courts say. All unvaccinated employees must wear a face covering. Those with a disability or a sincerely held religious belief may be entitled to a reasonable accommodation. The emergency temporary standards contain very specific guidance regarding the paid time off that you must provide employees to obtain the vaccine and to recover from any side effects. However, the federal emergency temporary standards no longer provide paid time off for testing. In California, the Cal OSHA originally, it was anticipated the adoption of the Horcher proposal, which would have taken effect today, that they would adopt the emergency temporary standards verbatim. That is not going to happen now. Cal OSHA cannot adopt a federal rule that is not in effect. So Cal OSHA will, I know this might be shocking, will likely forge its own path for California employers. Meanwhile, we recommend that California employers continue to have a COVID vaccination policy, as well as include within your policy treatment of how you treat vaccinated employees versus unvaccinated employees, testing requirements, quarantine requirements. You allow unvaccinated employees to work if they test negative every 7 days and wear a mask. Maintain proof of employee vaccinations and test results. Self-verification is allowed. As I said, it's different from the emergency temporary standards. And we recently ran into a situation with a client where an employee was not complying with the employer's COVID-19 policy, prevention policy. And the employer requested advice on that. We advise that it is essential that employees comply and follow any COVID prevention policy that you adopt and implement. So this is not something that we recommend you take lightly. We want you to maintain all your record requirements, implement training requirements, and have your COVID-19 officer who is responsible for administering the policy. And any questions you have, we're certainly happy to provide any assistance we can to help you with this. So increases in minimum wage. As of January 1, they will increase again. 25 or more employees, the minimum wage is $15 per hour. Under 25 employees, the minimum wage is $14 per hour. Please note, however, that it is very important that you check your local city and county ordinances for higher minimum wage and paid sick leave rules. We've encountered some changes just in the last few weeks where certain employers are subject to higher minimum wage. For those employees who are exempt and who must meet the minimum salary requirement in order to meet that exemption, the salary requirement has increased. The minimum for a large employer is $62,400. For a small employer, those with under 25 employees, the minimum salary requirement is $58,240. Computer employees do have higher amounts, so if that's an issue, please let us know and we can assist with that. Harassment training. This is something that you should keep on your radar every year for the foreseeable future. As you know, that the requirements changed in the last couple of years, and employers with 5 or more employees must plan for harassment training for all employees every 2 years. Managers and supervisors must receive at least 2 hours of training every 2 years. All other employees must receive 1 hour. Also note that this applies to all harassment training. It is not simply sexual harassment training. It is all forms of harassment based on a protected class under the Fair Employment and Housing Act. We can assist you with training. We have a number of consultants that provide training as well. Severance agreements. This is a new requirement for 2021. If you've used severance agreements in the past, and those are any kind of settlement or severance agreements that you use for departing employees to resolve any potential claims that an employee may have, the legislature has adopted what they call the Silence No More legislation, and it's intended to protect individuals from any prohibitions against discussing harassment in the workplace. And again, that's all forms of harassment. In particular, severance agreements must include mandated language, and departing employees must be provided with a recommendation to seek legal counsel and the opportunity of 5 days to consider any severance agreements. As I said, if you've used severance agreements in the past, you know that the Older Workers Benefit Protection Act requires that you provide 21 days to any employee who is 40 years or older. So if you're 40 years or older, you're considered an older worker, which I've never happy to read that, but any employee who is 40 or older must have 21 days to review any severance agreement. And then if you're offering a severance package with respect to any reduction in force that affects 2 or more employees, the number of days to review increases to 45. But now all agreements must include a minimum of 5 days to consider and to seek legal review. Again, the silence no more does not apply just to severance agreements. It applies to all of your non-disclosure and non-disparagement agreements. I would argue that this includes any confidentiality policies that you may have in your employee handbooks and any non-disclosure agreements you provide your employees upon employment or anytime during the employment relationship. And it requires that you include very specific language that relates to all claims of harassment, discrimination, retaliation, and the failure to prevent any form of harassment. The language is nothing in this agreement prevents you from discussing or disclosing information about unlawful acts in the workplace, such as harassment or discrimination, or any other conduct that you have reason to believe is unlawful. And that specific language must be included. Arbitration agreements. This has been a hot topic in the courts in the last few years. The legislature passed legislation that required that arbitration agreements must be voluntary. This was immediately challenged in federal court on the basis that the Federal Arbitration Act preempted any state laws governing arbitration agreements. It was enjoined for a certain time period. That injunction has now been lifted by the California Court of Appeals, and this law is in full force and effect, at least for the time being. It is anticipated that the Chamber of Commerce will pursue an effort to enjoin this and have this law struck down as preempted and take it all the way to the Supreme Court. But for the time being, any arbitration agreement that you have with an employee must be entirely voluntary. And what this means, or how we interpret this, is that if you offer an arbitration agreement, which is an incredibly effective tool to use in protecting an employer from any potential liability and from protecting yourself from potential class actions, that you not attach it to any offer of employment. So you can't make the signing or agreeing to an arbitration agreement contingent upon acceptance of at-will employment. That also means that you should not attach it to your employee handbook, because it suggests, when you attach it to your employee handbook, it suggests that it is related. So we want you to use separate documentation, separate forms, and allow individuals the opportunity to review their arbitration agreements and to sign voluntarily. If you have any questions or require an arbitration agreement, we do have those available and we'd be happy to assist. Again, we do highly recommend that you adopt and use those. Cal OSHA, again, has been quite busy, and they have adopted and expanded their enforcement abilities. They have adopted 2 new violations. One is referred to as the enterprise-wide violation. This creates a recognized rebuttable presumption that a violation is committed by an employer with multiple work sites is enterprise-wide. So if you have multiple work sites and you have one policy and procedure for all such work sites, and a violation occurs at one of those work sites, Cal OSHA will presume that the violation occurs enterprise-wide. It increases the amount of potential penalties that are assessed for any violations. In addition, they now recognize what's referred to as an egregious violation. This is any willful and egregious violation of an occupational safety or health standard, order, special order, or regulation. And each instance of an employee exposed to that violation shall be considered a separate violation. Again, this expands the enforcement capability and expands the potential for liability. So it's essential that you keep these in mind. California Family Rights Act, in 2021, California Family Rights Act, CFRA, the California version of the Family and Medical Leave Act, was extended to all employers with 5 or more employees. And so you're pretty much prepared to expand that. They have now extended any Family Rights Act leave of absence to include parents-in-law. So you'll need to update your employee handbooks to reflect that change. We can assist you with that. Again, we're happy to review any handbooks. If you have not reviewed your handbook for either 2021 or 2022, we highly recommend it, and any one of us can assist you with that. Record keeping under the Fair Employment and Housing Act. Again, this is an expansion of existing law. Up until now, you've been required to maintain any FEHA-related records, employment-related records, for 2 years. Now it has been increased to 4 years. So if you have a record retention policy, or either informal or formal, you'll need to revise that and update it. Most employers keep things for longer than 2 years anyway, so it's probably not that big of an issue, but it's something that you should be aware of. Independent contractors versus employees. This is a huge issue and has been a huge issue for several years. It continues to be a huge issue. Anybody who uses independent contractors or who has independent contractor agreements, we highly recommend that you discuss this issue with us. It will be very rare for any worker who is providing services for you to be an independent contractor, and there are very strict guidelines. The liabilities are nothing to play with. You do not want to deal with a misclassification issue. It subjects you to all employer-related claims. And so AB5, which took effect in 2020, it continues to be updated and expanded to include certain exemptions under AB5. Nonetheless, even if a classification has been considered exempt under AB5, the independent contractor rule, and the test, the ABC test, which we'll talk about in a minute, that doesn't mean that they are truly exempt. You still need to conduct that analysis to determine whether they are exempt under the Borrello right to control standard. So please keep that in mind. It will be very rare for an individual to be considered an independent contractor. It does require a written contract, and we can certainly assist you with that. I'm happy to do so. I've done a number of these. The AB5 test, as I said, you must meet each of the 3 requirements. The first is essentially the Borrello standard, the right to control, that the worker is free from the control and direction in connection with the performance of the work, both under the contract and in fact. And one of the big issues here is that it is a factual analysis. If there's a question as to the classification of an individual as an independent contractor, that subjects you to a fact-intensive analysis to what that worker is actually doing for you. And the title and what you call them and whether the worker wants to be an independent contractor is not relevant. It is what they're actually doing. The second part of the test is that the worker performs work that is outside the usual course of the hiring entity's business. An example of this would be hiring an outside accountant for your manufacturing business, hiring an outside attorney, hiring an architect for anything that, to not perform architecture work, but within your business. But and then the third is that the worker is customarily engaged in an independently established trade, occupation, or business of the same nature as the work performed. So does this worker hold themselves out in the community as providing this particular service? For example, architecture services, accounting services, attorney service, legal services, and is it independent? Also, an important question to ask is, under California law, are they required to maintain a license under California law, such as a welder or anybody who performs construction work? If they are required to maintain a license, they must have evidence of that license, and that will demonstrate that third prong of the test. Excuse me. Background checks continue to be a significant issue. As you'll recall, there was a push in the last few years for ban the box to eliminate any questions regarding criminal backgrounds and arrest records rather than conviction records for employees. The court decisions are continuing to limit what employers can discover about an individual in their criminal records. It's very important that if you use an outside service to conduct any background checks, including criminal background checks, that outside service complies with the Federal Consumer Reporting Act. And you should feel free to request any verification of their compliance with the Federal Consumer Reporting Act. There are also increased penalties for wage theft. So what is wage theft? A perfect example of that would be any employee who receives tips or gratuities as part of the services that they provide, and the employer withholds a percentage or a portion of those tips and gratuities. That would be considered wage theft under California law. New AB 1003 creates a criminal penalty for withholding of wages, tips, gratuities, wages, commissions, any form of compensation that you provide your employees. This law applies to both independent contractors and employees. So very important to note there. It increases the penalties and also creates essentially a crime, and the commissioner can determine whether it's charged as a misdemeanor or a felony conviction. As I had stated previously, many of the laws that California legislature adopted this year are industry specific. Two of the biggest examples of those are rules for warehouses and the garment manufacturing industry. For warehouses, those who employ 100 employees at one work site location or 1,000 or more employees in California, the employer is required to disclose any quotas that they apply to determine employee wages and compensation, and they must protect employees' break and meal time, including the opportunity for bathroom breaks. It states that specifically. For garment manufacturers, although the law has previously stated that piece rate compensation was not permitted under California law, that has now been expanded and clarified to state that that extends to any subcontractor relationships and to brand guarantors. So if you are a garment manufacturer and you have any contracts with subcontractors, it must include provisions to prohibit the use of piece rate pay and to provide that all employees must receive at least the applicable minimum wage. Now, you can still use piece rate pay in addition to any minimum wage, but it can't be in lieu of. Pay for meal and rest breaks. The court decisions in the last year have clarified that employees paid piece rate or bonuses must be paid for time spent on rest breaks. That's the bathroom breaks I mentioned. There is no de minimis time allowed for giving a full 30 minutes or more meal period. That would suggest that you should not adopt any rounding policies surrounding the meal break, either before or after the meal break. No rounding at all. And we'll talk about rounding in a little bit more in a minute. Rest break and meal period violations, remember, require the payment of a 1 hour penalty per violation. And this is a common basis for lawsuits. So please be aware of this limitation and restriction. Another thing that you'll need to keep in mind with respect to any contracts with janitorial services, have you verified that the company that's providing janitorial or cleaning services is appropriately registered with the California Labor Commissioner? That is a new requirement. You'll need to adopt that. Again, you are entitled to any proof of compliance, and that should be included in any contract or agreement you have with your janitorial service. Time rounding, this goes back to what we discussed in a minute. The California court did uphold the legality of the employer's practice of rounding employee time entrance to the nearest quarter hour, 15 minutes for payroll purposes. But the holding was based on expert analysis of time and pay records. So we caution you on any use of rounding policies. Again, There should be no rounding surrounding the meal break, the time reporting to work or leaving work at the end of the day. You may have some flexibility, but it is fairly limited. And we suggest that you contact us for any guidance in this area in the event that you do use any time rounding policy. Cal OSHA, again, we recommend that based on Cal OSHA's very aggressive position lately, and the fact that fines are increasing and they have hired a number of new inspectors, that you conduct a safety audit this year. And we can certainly assist you with that. We offer a free safety audit by our experienced safety team, and we can verify compliance, minimize citations, provide training, and ultimately save you money for those provisions. Just ask you to send us an email at info@calworksafety.com, calworksafetyhr.com, sorry. Legislative analysis. We have also prepared a complete summary and analysis of the laws we've talked about today. If you'd like that information, please, again, email us at info@calworksafetyhr.com, and we'll be happy to provide that. We are always here to help, and we appreciate the opportunity to work with you and to provide you with any support and services that you need. We hope that you'll contact us. And I think we can open it up now to any questions you may have about the presentation or anything you want to chat about, questions, concerns. We have, I'm available for questions, and Don Dressler is as well. Thanks so much for your time.
All right, so our first question here is regarding exempt employees. What is a large versus small employer? Is a large employer 50 employees?
There are no distinctions for the classification of exemption. Exemption falls under both the wage and hour laws for California, but also under the Fair Labor Standards Act. And exempt versus non-exempt is not related to employer size.
The requirement of double the minimum wage does, though, depend on size, and the large employer is 25 or more employees. So employer with 24 or less is small employer, 25 or more is a large employer.
Right.
Please define the difference between independent contractor versus consultant.
It's a very good question. You want to do that, Don? Okay.
Yeah, a consultant is a form of independent contractor. The question is, what are they doing for you? Many times when a consultant comes in, or the same thing as a plumber or an electrician or some repair person, they're coming in to work for the business on its own business activities. If they're coming in as a consultant to do work for your clients or your customers, that's a big difference. A consultant is just a term of art. You could simply easily call it a briefcase carrier or an electrician. But the question is, who are they doing the work for? Who's the beneficiary of the work? And that leads us then to the analysis under the independent contractor laws.
And lost my place here. If we have employees who work remotely, do we need to ask about their vaccination status?
The only question about employees who work remotely are, do they ever come to visit your office or go to visit customers? If they merely work at home, and that's the term often used, not remote, there is an exemption under the draft rules. And of course, Cal OSHA's rules require wearing masks for unvaccinated people at work, not at home or where no one else is present. If you just think about working remotely, if they're working remotely on a construction site with 10 other people, they're not working alone. If they're working from home and doing their work electronically, then they're going to be exempt. My suggestion is you make sure you have a roster of employees. And why wouldn't you ask that question just so you know in case the rules change, which they're likely to change.
And I think I would add to that any employee who does test positive for COVID, who works remotely and tries to claim any benefit, it is not considered a work-related illness or injury then.
All right. And the next question, we have an employee whose spouse died yesterday due to COVID or COVID related issues. What can we do as an employer? He is now sole support of 4 teenage kids.
Well, let me just say, first of all, condolences to everyone involved in that circumstance. It's a sad circumstance. Because it's dependent of an employee, you need to look at your benefit packages and your insurance benefit to see if there's any benefit. Realize some health insurance plans have a benefit, even in addition to whatever life insurance. You also need to know what your own company's bereavement policies are. In a situation like this, depending on your workforce, consideration and support by the employer can go a long way. And you might also alert coworkers so that they're appropriate in their response, and often they'll want to help as well. Let me just make one general observation about employees and dealing with these kind of situations. In the last month or two, we've had 4 million people leave the workforce in the United States, and many of us are calling this the Great Resignation. Employers who are attentive to their employees, support them, show them they care, show them they're interested in their well-being, are doing a better job at retaining workers than those who are not paying attention to morale and company culture. This is a time to be sensitive and supporting to the extent you can and have your business be operational.
We have someone asking if we can re-review the slide on keeping vaccination records.
Sure. Any particular question that someone has regarding maintaining vaccination records?
No.
I would just tell you that we will make available a copy of the PowerPoint to anyone who sends in an email request. Mm-hmm. And the recording of this program will be posted within the next day or so on YouTube. And also, just by requesting it, you can get the analysis of the new laws that Liz has prepared. That may be easier, but just in short, we would suggest that you have some form of roster that lets you keep a list of all your employees to indicate who is vaccinated and who is not. And we also have a sample roster form that we can make available to you. We'd suggest that you, if you can, you'd know who's vaccinated or not and when, because timing is becoming important. Although fully vaccinated still defined by the original approval of the FDA for Pfizer or Moderna or J&J, we would anticipate in the next several months, the definition of fully vaccinated is also going to contemplate the role of booster shots. So having what vaccine the employee received and when will be very helpful to you in terms of coping with these changes as they evolve.
Let's see here. The janitorial service is a new one for me. How do we get outside service to give me proof they are registered with a California labor com? And what if they don't know they should be?
Well, first of all, there are a lot of individual janitorial service people, and there are some exemptions from the Janitorial Registration Act if you're an individual and have no employees. But the problem is if there's any person who's an employee who is hurt on the job, not paid the minimum wage, not paid the appropriate wage, and you don't know whether, if your janitorial service is not in compliance, your firm is going to be liable for those violations. There's a website. Also, our consultants have worked with this. We've even helped firms file for registration with the Janitorial Services Act. If you're running into anyone with that question, let us know. Any of our consultants would be happy to help you with that. But you should know who does your janitorial work if you're paying an outside service. Now, if you have an employee doing this work on your payroll, this rule doesn't apply. This is for outside firms.
Regarding minimum, oh, sorry.
Jake, hang on just a second. I think we missed one. There was a question about FMLA, request to be updated on how to handle this. And I just suggest, I think that you contact us directly and we can assist you with any specifics. Really, it's kind of an open-ended question, and we'll be happy to help with any specific questions that you have or any updates that you need on FMLA or California Family Rights Act.
Regarding minimum wage, does state rules supersede local governance regarding minimum wage?
No,
Yes.
the highest
No.
rule applies.
Local and city will and county will supersede the state. So
Usually the local rates are higher anyway. So
yeah.
Does the company pay for the test and let them use company time for an unvaccinated employee to get tested every 7 days?
well, let me just say, this is one of those areas where we had proposals from the federal government. We have Cal OSHA rules. The Cal OSHA Standards Board is meeting today on its COVID standards. Its current standards expire in January, and the emergency period that they currently operate under expires in April of 2022. So this is something I would suggest that we talk with you about in your own company policy. We have helped many of our clients write their COVID policies. Some of those policies include reference to vaccinations. The questions become very important there. When do you have to pay for the test, and when do you have to pay for time off? And I would suggest that rather than try and give you an easy all-purpose answer, that we sit down and say, what is your policy? What do you want? If it's an employer mandate under California and it's essential to conduct business for the employer, there's a labor code provision about reimbursement. So let's work with you on a policy that makes sense. I mean, the short answer is somebody does a test on their own time away from work and you didn't ask them to do it, you don't have to pay for that. But anything else than that starts to become, let's talk about the circumstances.
Since EPSL was discontinued end of September 2021, based on federal rules, do we still pay employees who are absent due to vaccination?
No.
Well,
only under the COVID rules. I mean, but there's
right. The federal rules will require it, but not yet. So Don, go ahead. Sorry.
Yeah. So I think this gets into your whole policy about sick pay, paid sick leave, which of course is anywhere from say 3 to 5 days a year, depending on your jurisdiction. I would also tell you that the EDD, state disability insurance, and paid family leave are still available for compensation. So you may not need to pay. You're certainly not required under the federal law that's expired. And let's make sure you have a policy that works for your company that combines those benefits between paid sick leave and state entitlements and whatever Cal OSHA's requirements are.
Can we select employees for specific projects, and would this fall into discrimination? Should we retroactively ask employees details about their status, date, and type of vaccine?
Two things. Selecting employees for projects, you can do anything in California as an at-will state too, as long as you don't do it on an improper basis or for an improper purpose. So if you're selecting people because of age, sex, national origin, religion, hairstyle, genetic information, gender expression, all the protected classes, and hopefully you have a very detailed EEOC policy in your handbook. And we suggest it lists all the protected classes because the California Fair Employment and Housing Commission has a rule that asks for that. That would give you some guidance. But if you're picking people because they're the best at the job, they have experience in the job, those are perfectly legitimate reasons to make a decision. I don't think I recall the second part of the question.
Should we retroactively ask employees details about their status, date, and type of vaccination?
I think Yeah, I think you should. If you prepare a roster of employees, and some of our clients have already done this and been very careful with it, even including getting copies of vaccination cards. But I think, unfortunately, the rules are going to change and change quickly. And if you have to scramble then to start to find out who's vaccinated and not, you're behind the curve. I would suggest you do it at a time when it's convenient, when you have an opportunity, so you're ready. Because the odds are overwhelming, you're going to need a list of your employees who are vaccinated. And how do you enforce the mask policies if you don't know that anyway? The current Cal OSHA rule requires unvaccinated people to wear masks. How does your foreman or supervisor know if someone's vaccinated if you don't have a record?
Is there still government help available for COVID sick pay?
No.
Okay, I think that's our last question. If we have any more questions. All right. Well, thank you very much for sharing. This is an important topic. Remember, if we didn't address your question today, go ahead and reach out to us. As a reminder, CalWorks Safety and HR is dedicated to helping businesses remain compliant and successful during the COVID-19 pandemic. Again, be on the lookout for future topics on our website at calworksafetyhr.com. Thank you for joining us. Stay safe, healthy, and have a wonderful day.
Thank y'all. Have a great day.